Welcome to Ask the Lawyer radio podcast with attorney Brian Figueroa of the law firm Figueroa and Associates. This podcast features a recording of our most recent radio show. We hope you enjoy the show, which features news, views, and interviews on matters such as immigration, personal injury, bankruptcy, divorce, family law, estate planning, wills and probate, deed transfers, civil rights, criminal defense, workers' compensation, and taxes, both individual and business. You can contact us at 855-768-8845 or visit us at www.askthelawyer.us. You have questions? We've got the answers.
Guardianship in New York challenges when the guardian is an adult child living abroad. Guardianship laws in New York City, NYC, and New York State, NYS, are designed to protect individuals, commonly referred to as wards, who cannot manage their personal, financial, or medical affairs due to physical or mental incapacity. In cases where an adult child living outside the United States and not a U.S. citizen or green card holder is named as the guardian, unique legal, logistical, and ethical challenges emerge. This article examines the guardianship framework in NYC and NYS, explores the complexities of having a non-resident guardian, and outlines possible solutions to navigate these challenges. 1. Overview of guardianship laws in NYC and NYS. Legal framework. Guardianship in New York is primarily governed by Article 81 of the New York Mental Hygiene Law, MHL, and to a lesser extent, Article 17A of the Surrogates Court Procedure Act, SCPA. Article 81 Guardianship. Designed for adults who cannot manage their personal or property needs. Guardianship is tailored to the specific needs of the ward, with the court granting only the powers necessary to meet those needs. Article 17A Guardianship. Used primarily for individuals with intellectual or developmental disabilities. Unlike Article 81, this form of guardianship is more comprehensive and less tailored to specific needs. Types of guardianship. Guardianships in NY are categorized into guardian of the person, responsible for decisions about the ward's personal and medical care. Guardian of the property, manages the ward's financial affairs. Guardian of the person and property, oversees both personal and financial matters. 2. Requirements for becoming a guardian. General eligibility. To qualify as a guardian under NY law, the individual must be at least 18 years old. The person must have the ability to perform the duties assigned by the court. The court must determine that appointing the individual is in the best interest of the ward. Non-resident guardians. Non-residents can be appointed as guardians under NY law, but their status introduces additional complications. When the proposed guardian resides outside the United States and lacks legal residency, example, a U.S. green card or citizenship, the court may impose stricter requirements to ensure the ward's interests are adequately protected. 3. Challenges when the guardian is an adult child living abroad. Legal challenges. Immigration status. A guardian who is not a U.S. citizen or green card holder may face difficulties entering the U.S. to fulfill their guardianship duties. Without a valid visa, the guardian may not be able to attend court hearings, supervise care, or handle financial transactions. Court oversight. Guardians must periodically report to the court on the ward's well-being and financial status. A non-resident guardian may find it challenging to meet these requirements without physical presence. 3. Residency requirements for financial transactions. Banks and financial institutions often require guardians managing property to have a U.S. address or valid tax identification number. This poses logistical barriers for guardians living abroad. Logistical challenges. Coordination of care. Guardians are responsible for ensuring the ward receives proper care, which can include managing medical appointments, coordinating with care facilities, and overseeing day-to-day needs. Physical absence can make these tasks significantly harder. Time zone differences. Guardians living in a different time zone may struggle to communicate effectively with care providers, financial institutions, and legal representatives in the U.S. Travel limitations. Frequent travel to the U.S. may be financially or practically unfeasible, especially if the guardian has employment or family obligations in their country of residence. Ethical and emotional challenges. Cultural differences. Differences in medical and elder care norms between the U.S. and the guardian's home country may lead to conflicting decisions about the ward's care. Emotional distance. A non-resident guardian may find it harder to maintain a close, supportive relationship with the ward, potentially affecting the ward's mental and emotional well-being. 4. Court considerations in appointing non-resident guardians. The court must determine whether appointing a non-resident guardian is in the best interest of the ward. Key factors include the guardian's ability to fulfill duties. The court will assess whether the proposed guardian can effectively manage the ward's personal and financial needs despite living abroad. Proposed care plan. The guardian must present a detailed plan for overseeing the ward's care, including local support systems and communication methods. Alternative arrangements. If appointing a non-resident guardian is deemed impractical, the court may explore alternative arrangements, such as appointing a co-guardian or standby guardian based in the U.S. 5. Case study. Hypothetical scenario facts. Maria, an 82-year-old NYC resident, suffers from dementia and needs a guardian to manage her medical care and finances. Her adult son, Daniel, lives in Spain and is neither a U.S. citizen nor a green card holder. Daniel wants to serve as her guardian. Challenges. Daniel cannot travel frequently to the U.S. due to his work obligations and lack of a long-term visa. Maria's bank requires her guardian to have a U.S. Social Security number to manage her accounts. The court questions whether Daniel can adequately supervise Maria's day-to-day care from abroad. Proposed solutions. Appointing a local co-guardian. A trusted family friend or professional guardian in NYC could be appointed as a co-guardian to handle immediate, on-the-ground responsibilities. Leveraging technology. Daniel could use video calls and remote monitoring tools to stay involved in Maria's care and communicate with her medical team. Standby guardianship. The court could designate a standby guardian in the U.S. to take over if Daniel is unable to fulfill his duties. 6. Best practices for non-resident guardians. Build a support network. Establish relationships with local caregivers, attorneys, and financial advisors who can assist with the ward's needs. Adopt technological solutions. Used digital tools for remote communication, financial management, and health monitoring. Plan for visa requirements. Work with an immigration attorney to secure a visa that allows periodic visits to the U.S. for guardianship-related duties. Seek legal advice. Retain a guardianship attorney familiar with cross-border issues to navigate the complexities of NY law and ensure compliance with court requirements. 7. Legislative and policy considerations. Existing gaps in the law. While NY law permits non-resident guardians, it lacks specific provisions addressing the unique challenges faced by those living abroad. This can lead to inconsistent outcomes in court decisions and difficulties for guardians. Potential reforms. Clear guidelines for non-resident guardians. Introduce legislation clarifying the responsibilities and limitations of guardians residing outside the U.S. Use of technology. Encourage courts to adopt remote reporting and monitoring systems for non-resident guardians. Facilitation of visa access. Create a special visa category for guardians of U.S. residents, allowing them to travel to the U.S. for caregiving duties. 8. Ethical considerations. Balancing interests. Courts must balance the ward's best interests with the guardian's ability to fulfill their duties. Appointing a non-resident guardian may raise questions about whether the ward's care could be compromised by the guardian's physical absence. Respecting family dynamics. Family ties and cultural values often play a significant role in guardianship decisions. Courts must navigate these dynamics sensitively, especially when family members are separated by borders. In conclusion, Guardianship cases involving non-resident guardians in NYC and NYS highlight the complexities of cross-border caregiving and the need for thoughtful legal and logistical solutions. While current laws allow non-residents to serve as guardians, practical challenges related to immigration, communication, and financial management require innovative approaches. By adopting best practices and advocating for legislative reform, families and courts can work together to ensure that wards receive the care and protection they need, regardless of geographical boundaries.
Do you have a legal issue, question, or concern? Turn to Ask the Lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us. You can also register for our paralegal program, get legal news, business consults, or other information on educational issues. Yes, ask the lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us.